If you steal something, like a ring or a car, and you hand it over to somebody, you're expecting something. So why did you hand her this engagement ring?
Jennifer Chambers came to court expecting a theft plea with probation, but one missing engagement ring changed the entire tone of the hearing. When Judge Boyd asked where the ring was, the case stopped being routine and turned into a deadline.
Court is calling 2025 CR 004-569 State versus Jennifer Chambers. Can I have parties announced?
Alexander Cross for the defense.
And are you Ms. Chambers? Did you review I'm sorry, counsel, have you received all discovery? Did you review it with your client?
We have, Judge.
Court will find that the state is in compliance with discovery. Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Judge.
All right, Ms. Chambers, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with theft of property, $2,500 to $30,000 as a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? I'm sorry?
Yes, ma'am.
Did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
She is and was, Your Honor.
Ms. Chambers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived the right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 2 years in the state jail facility. There's a $1,000 fine to be probated. There's to be restitution to the complainant in the amount of $7,025. Did you understand that to be the plea?
Yes, ma'am.
And I'm sorry, and the state is recommending community supervision. Is that the plea state in defense?
It is, Judge.
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is recommending your community supervision be for a term of 3 years and there be a TAP evaluation. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Judge, we offer exhibit number 1,
No objections.
And state, have you spoken with the complainant?
Yeah.
Thank you. You may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. All right, where's her engagement ring? What did you do with it?
I had to get to a friend and
You need to go get that ring back from that friend.
I don't communicate with her anymore. I don't.
You better pick up the phone, find that friend. This lady wants her engagement ring back.
I know that, my friend, well, she's not my friend anymore, but, she's, currently incarcerated.
Oh, well, you don't have her family members. I don't think they let her take the ring to the prison with her.
Right.
And why did you hand this ring over to your friend?
It was just bad decisions.
No. There's a
Sorry.
reason. If you steal something, like a ring or a car, and you hand it over to somebody, you're expecting something. So why did you hand her this engagement ring?
Because she said that she could be able to sell it.
All right, so here's the thing. I'm not gonna sentence you yet. You're gonna come in here on the day of sentencing with $7,025, because that's how much the appraisal is for that ring, and that's what you agreed to, the amount that you owe. And I'm giving you 60 days to come up with that amount. Is there anything else?
No, Your Honor.
All right, Ms. Ferguson, I need a 60-day reset. And you need to come in. State, is this by cashier's check or money order?
We have money.
All right. 60 days?
April 6th.
All right, April 6th.
Your Honor, I don't think she's gonna be able to get that amount of money in that amount of time.
April 6th, $7,025. She can either bring that or she can bring that person's engagement ring back. I think they probably prefer the engagement ring.
Your Honor, would we be able to withdraw the plea at
No.
that date?
She needs to come in with that amount.
But it's because we agreed to have the 3 years be the amount of time for her to get the money.
No.
I think we'd have to request a withdraw the plea. That was part of our agreement.
Mhm. All right. So state they want to withdraw their motion. Will you all be ready for jury trial on this tomorrow?
Tomorrow.
Yes.
Judge, I think plea has already been made on record. We're just holding it back for sentencing. They can't apply that now.
Well, here's the thing. I don't have to accept any plea bargain agreements that have been reached. What I'm telling you though is you're either going to come in here on February 6th with that $7,000 and $7,025 for the cost of that engagement ring, or either you need to come back here with that engagement ring and for the complainant to say, yes, this is my engagement ring. So, April 6th. And if you don't have that and you want to, I'll consider not accepting your plea and we will be going to jury on that day.
All right, thank you, Your Honor.
All right, once you sign the reset form, you're excused. 2022 CR 1257, State of Texas versus Juan Carvajal. Five parties announced for the record for the state,
Ryan Gerber for the state of Texas.
for the defense.
Ernesto Acevedo for the defendant.
Defense, I'm showing you what's entitled discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
I did.
Court will find that the state is in compliance with discovery. Mr. Carvajal, I'm showing you what's entitled application for community supervision. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
Next, I'm going to show you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, we do.
State, are you proceeding on the indictment as presented?
Judge, if you may you advise me what we're doing?
Sorry.
Straight possession.
Proceeding on count 2.
Okay, Judge, we'll be proceeding on count 2.
All right. Any objections to the waivers of count 1 and 3?
No, ma'am.
All right, I'm going to show you what's entitled court admonishments and defendant's waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
In count 2, you're charged with possession of a controlled substance, felony group 1, 4 grams to 200 grams. So it's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, he was.
Mr. Carvajal, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, state is proceeding on count 2. Punishment is to be assessed at 4 years in the prison. There's a $1,500 fine. State recommends community supervision. They will take in consideration 2022 CR 1256, and there's $120 restitution for laboratory testing. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense is at the plea bargain agreement.
It was judged, but I believe the fine is recommended to be probated.
All right,
We have no objection to that, Judge.
all right. And state, do you understand that to be the plea bargain agreement?
It is, Judge.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Mhm.
Counsel, are there any such motions?
No, ma'am.
Next, I'm showing you outside the plea bargain agreement. Defense is requesting that your community supervision be for a term of 4 years. There'll be a TAP evaluation and 120 hours community service restitution. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations?
Yes, ma'am.
Then in count 2, how do you plead? Guilty, not guilty, no contest?
No contest.
State any evidence.
Yes, Judge. State would offer State's Exhibit number 1 and all attachments.
No objections.
Mr. Carvajal, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. Reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Please, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor, Rusty followed the plea bargain. He has had an issue with meth. He's been doing better the last year. But he's accepted responsibility for the case and is competent to complete a 4-year probation.
All right, Mr. Carvajal, if you're drug tested today, what are the results going to be? And before you tell me no, that you are getting drug tested today. So when I place people on probation, I'm hoping that they're going to be successful and complete everything. You understand?
Mhm.
So if you're drug tested today, what are the results going to be?
Oh, that'd be positive.
And what are you going to be positive for?
Marijuana, meth.
All right, how often are you using?
David,
Okay. Do you have any children?
do
What are their ages?
2 and 1.
Do they stay with you?
Yes, ma'am.
And is there anyone else at home with you?
Mom.
Your mom?
No, their mom.
Their mom?
Yeah.
Okay. And is she using?
No, not at all. Swear.
Well, I mean,
I understand.
you really don't know that. This is what I discovered in my time on the planet.
Mhm.
Even though I have more of my life behind me than in front of me, it's still considered a short time on the planet. What I understand is that when people go to the barber shop, at some point in time, they're going to get a haircut. And you know what that means? That means when people are hanging out with people who do drugs, at some point in time, they're going to end up doing drugs.
I understand.
So what I do know is that people who are using drugs should not have minor children dependent on them, because they can't depend on them. You understand?
Yes, ma'am.
Are you employed?
Self-employed.
Doing what?
Landscaping.
All right. Here's the thing. I'm going to want you to have a real job. And I think that landscaping is a real job, but when I say a real job, I mean that there's actually a business. That's not you knocking on a door and saying, hey, you need your lawn.
We're established.
What's the name of your company?
Chris the yard guy.
All right. And are you a worker there, or do you own it?
Own.
Okay.
There's so far shit.
All right. You're gonna have to provide proof of that. He's gonna have to
Okay.
provide
I
proof.
did 6 months on monitor and we were able to provide
Okay.
proof for that. So
All right. This is what the court is gonna do. The court is gonna sentence you to 4 years in prison, suspended and probated for 4 years, $1,500 fine. That'll be probated. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There's not to be any unsupervised contact with minors. Mr. Acevedo, that may change once he is negative and gets his life in order with regards to that. So no unsupervised contact with minors. So what that means is you're not allowed to babysit your children. That means that if your wife needs to go to the grocery store, and I know it takes a lot to put babies in car seats and everything, she's gonna have to do it because you can't be with the children by yourself. You understand?
Yes, ma'am.
I'm gonna run a referral to felony drug court. And you need to be honest with them. Don't come back to my court with them saying that you say you don't have a drug problem, because you do, and they'll be able to help you with it. It's a difficult program, but trust me, once you work through it and work the program, you'll be better for it. You understand?
Yes, ma'am.
And if you're accepted, I won't say if, when you're accepted into felony drug court, all of the conditions that I'm giving to you now, they will be in charge of that, and they may change your conditions. You understand?
Yes, ma'am.
I'm gonna want parenting classes, 120 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. Court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. I'm going to waive the remaining of those hours once you complete parenting classes, and you must complete parenting classes. You understand?
Yes, ma'am.
I'm gonna want field visits, probation. I am sorry, but there are minors in the home. I'm gonna want field visits, random 3 times per month. Please make sure you check on the children. We'll do a TAP evaluation plus follow recommendations. And that's if he's not accepted in felony drug court. There's gonna be regular reporting by Zoom or in person. Taking consideration 2022 CR 1256. $120 restitution for lab testing. Probation, is there anything else he needs?
Your Honor, did you say anything about his urinalysis?
We're gonna do the UA hotline until accepted into felony drug court.
Thank you.
All right, is there anything else you need from the court in order to be successful?
No, that's perfect.
All right, I'm gonna show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it, and did you sign it?
Yes, ma'am.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what the definition of a weapon or ammunition is, you'll need to speak to your attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Mr. Cabral, I cannot express to you deeply enough. Young children learn by doing what they see. When they learn to speak, you know how they learn to speak? Because they listen to other people or they see something on television. You don't want your children to learn that drug use is okay because they're seeing you. And I know a lot of people think, well, I'm not using in the home, I'm using outside, but children know.
Mhm.
And then you don't want them teased at school, because if they go to school and they smell like marijuana, they'll be talking, the children will talk to them, right? Children are cruel.
Yeah.
All right, so do better.
Yes, ma'am.
All right, probation is going to go over conditions with you. Where would you like him to go for conditions?
Your Honor, I actually left Mr. Acevedo a message for him to give me a call, and I can get all the information I need.
All right, thank you. Court is calling 2023 CR 1042, State of Texas versus Celine Renee Briard. Can I have parties announced for the record for the state?
Hank Wilkes for the state, Your Honor.
Defense?
Robert Gaona for the defendant.
Are you Celine Briard?
Yes, ma'am.
How do you pronounce your last name?
Briard.
Briard? Oh, I was doing great. Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Briard, I'm showing you what's entitled application for probation. Did you review that with your attorney? Did you understand it, and did you sign it?
Yes, Your Honor.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor, but
We're waiving count 2.
Any objection?
No objection, Judge.
Ms. Briard, I'm showing you what's entitled court admonishments. Did you review that with your attorney? Did you understand it and did you sign it in all the appropriate places? In count one, you're charged with the offense of fraudulent use or possession of identifying information, 5 items or more. That's a state jail felony. Range of punishment is anywhere from 180 days in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
And up to 2 years in the state jail facility. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
All right, we can go off the record. Are you all in agreement with her having probation or?
Yes, Your Honor. Sorry.
Okay. All right, we're back on the record. Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, I do.
Ms. Briard, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No,
Has anyone promised you anything other than the plea?
no.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived a right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it? According to the plea, the state is proceeding on count one. Punishment is to be assessed at 2 years in the state jail facility. There's a $500 fine to be probated. State recommends community supervision. There's to be restitution, if any, to Juan Palomino, P-A-L-I-M-I-N-O. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the agreement. State is requesting that your community supervision be for a term of 3 years. There be a TAP evaluation, 100 hours community service restitution, and no contact with Juan Palomino. Did you understand that to be the agreement?
Yes, ma'am.
Defense, is that the agreement?
It is, Judge.
State, is that the agreement?
Yes, Your Honor.
Just one moment, I'm sorry. I am so sorry. What threw me off is that the name has been spelled differently and the no contact order. So what's outside the agreement, which means that the state and the defense may have come to an agreement, but I don't have to follow it. So outside the agreement, the state and the defense have both agreed that you should be placed on community supervision for 3 years, but I could place you on community supervision for more than 3 years. Do you understand?
Yes, ma'am.
They've agreed that you do the TAP evaluation. I can either say yes to the TAP evaluation or no to the TAP evaluation. Do you understand?
Yes.
I could either say yes or no to the 100 hours of community service restitution. I can give you more than that. Do you understand?
Yes.
And there's a no contact with Juan Palomino. And the way it's spelled in that is P-A-L-O-M-I-N-O. Did you understand?
Yes, ma'am.
All right, then to the offense as charged in count one, how do you plead? Guilty, not guilty, or no contest?
Contest.
State, any evidence?
Your Honor, I submit State's Exhibit 1 and the attachments.
No objection, Your Honor.
All right, state, you may be excused.
Thank you, Judge.
Ms. Briard, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We'd ask that you would, Judge.
Anything you wish to say on behalf of your client?
Judge, that if all of the plea bargain agreement allowed her to be released today, she can report for any type of appointments that are necessary for completion of probation.
All right. So how many children do you have? All right, excuse me. In this area, you all are blocking probation. She cannot hear, she cannot see.
I have 3 children. And I'm expecting.
All right. How old are your 3 other children?
They're 2, 3, and 5 months.
And where are they?
They're with their grandmother.
So how long have they been with their grandmother?
A couple of months, Judge.
Why?
I just had some things going on. I thought it was best for my mother-in-law has custody of my kids right now.
Why does she have custody?
Because I had
I'm sorry, you're gonna have to speak
I
up.
had a CPS case going on because of my son had got out of the apartment when everybody was sleeping early in the morning, and so
Is this the 5-month-old?
no, ma'am. They're 2, 3-year-old.
Okay. So you have a CPS case.
Yes, ma'am. It's currently about to be closed.
Oh, it's about to be closed?
Yes, ma'am.
So that means if it's about to be closed, that means, and your attorney does CPS work, right? So tell her what that means, counselor.
Judge, what happened was it turned out to be a safety plan, an investigation in which I met the safety placement, and she verified everything.
So,
If everything pans out, she knows it will be closed. If not, it could go legal. But
and the reason why they do the safety plans means exactly what it says, safety plan.
Yes, ma'am.
So what's your drug of choice?
I mean, I don't do any drugs right now, but I was using methamphetamines, but I've been sober for quite a while now.
All right, how often were you using meth?
Like maybe every week, every other week. It just depends.
When's the last time you used meth?
Like 4 months.
All right, so that's probably why CPS was involved. When's the last time you had employment?
I was right before I was arrested.
Doing what?
I was doing home health care and working for a hotel at the front desk.
All right, I can tell you right now, I don't allow people on probation here to be home health care providers.
Yes, ma'am.
How far did you go in school?
To the 8th grade.
See, and this is nothing about you, but this is my problem with home health care providers. Home health care providing is turning into West telemarketing. They don't do background checks. They're just letting anybody come in. And maybe I'm wrong for saying this, but they're looking at the bottom line, the dollar line. So I'm being told that they're letting somebody with an 8th grade education who has meth issues, who has 3 children that she doesn't even have custody for them, work as a home health care provider. Thank you, home health care provider people. So that is why I don't let people work as home health care provider. Now, maybe once you get your life together, maybe that will be a good fit for you, but I'm not going to allow that.
Yes, ma'am, I understand.
So why do you only have your 8th grade education?
I just never furthered my education, but I am in, actually, just before I got arrested, got some GD books from the library, so I am trying to pursue my GD.
Okay. So what are you planning on doing with your rest of your life? What are your hopes, your dreams?
Well, after I get my GD, I want to be a cosmetologist. So.
Okay. Hey, that's doable. But I will tell you this, anything that requires a license, when you have convictions before you start spending all that money to do it, you need to find out from the state, wherever you're going to be licensed, if that's going to be a hindrance to you. Not saying that it will stop you, but it may cause complications. All right, counsel, is there anything else?
Oh, yeah.
All right, this is what the court is going to do. The court is going to sentence you to 2 years in the state jail facility, suspended and probated for 4 years. There's a $500 fine that will be probated. There's to be 200 hours of community service restitution. I'm going to ask for parenting classes, probation, whatever parenting classes you deem would be appropriate for her. Obviously, it needs to be intensive, because for them to say that the children are to remain where they remain, that means that she didn't do any. So I'm going to want intensive. There's to be restitution and no contact with Juan Palomino. There's to be no unsupervised contact with minors. There's to be proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. Regular reporting by Zoom or in person. The UA hotline until further notice. Field visits 1 time per month until further notice. TAP evaluation in custody. Follow all TAP recommendations. If TAP is recommending outpatient treatment, then I'm going to want intensive outpatient treatment. If they are recommending inpatient treatment, then she can do intensive treatment and do a referral to felony drug court. I know that felony drug court is full, but maybe she can be placed on the wait list if they are recommending inpatient treatment for her. Probation, is there anything else she needs? Yes. All right, is there anything else you need from the court in order to be successful?
Judge, she'd like to know how much longer or how long she would be waiting for that TAP evaluation since you ordered it in custody.
Yes. Up to 2 weeks. Okay, thank you. All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, so here's the thing. Those 3 children, those are your children. It's not the grandparents' child. The grandparents are just supposed to be grandparents to children. They're not supposed to be raising more children, which is raising your children. You cannot have children and then tell them to go to Travis Park and say, you're on your own. And there is no reason a child should be able to get out of your house and you not know about it, and they're that age. So many things could have happened to your child when they got out of the house. Could have been hit by a car. And guess what? People can't see children that age because they're tiny and they're small. Somebody could have picked them up. And guess what? There's a reason we have indecency with a child cases in this court. Anything could have happened to your child. And when you're using drugs and you're pregnant, whatever you're using, your child is using too. So if you don't think a baby should be smoking a cigarette, you shouldn't be smoking a cigarette, because guess what? When you're carrying a child and you're smoking a cigarette, Your babies are smoking a cigarette. If you don't think a child should be doing alcohol, when you're drinking alcohol, your baby's drinking alcohol. You're gonna have to start making better choices. You understand?
Yes, ma'am.
Good luck to you.
Thank you.
Judge Boyd followed the plea agreement, giving Bryart 4 years of probation instead of sending her to state jail. But the conditions were strict. Treatment evaluation, drug testing, parenting classes, no unsupervised contact with minors, no home health care work, and proof of employment after release. The judge made it clear that the children's safety had to come first, especially after one child reportedly got out of the home while everyone was asleep.
All right, court is calling 2023 CR 10354, State of Texas versus Tony Torres. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense,
Jonathan Michelle for the defendant, we're ready.
are you Mr. Torres? Counsel, have you received all the discovery and did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Torres, I'm showing you what's entitled Application for Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Going to show you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am. Yes, I did.
Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
We are, Judge.
Mr. Torres, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it? Excuse me,
Yes, ma'am.
there's somebody coming up behind you. All right, did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with driving while intoxicated third or more? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Ma'am.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do. Just for the record, Judge, my client's made me aware that he has a learning disability, that he is bipolar. I've spent plenty of time with him. He understands what a jury trial is. He understands that he has the right to go to trial. He understands they're offering probation, and he understands what's going to happen if he doesn't follow the rules. So I joined him in his waiver, asking the court to accept the plea agreement.
All right. And do you believe he was sane at the time of the offense?
Yes, Judge.
Mr. Torres, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes, ma'am. 100%.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, I did.
According to the plea, punishments to be assessed at 4 years in the prison. There's a $500 fine. State recommends community supervision. There's to be ignition interlock for half the term, DWI intervention, VIP, and the 2-year driver's license suspension. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Judge. He's on home monitor right now. He is not driving. He's not driving the vehicle.
State?
Yes, sir.
All right. Do both parties understand if he presents the court with an affidavit of non-driving and an affidavit of non-ownership of a vehicle, and there is no vehicle that he has access to, then the court will order scram or some sort of mobile device and not the ignition interlock. Does everyone understand?
We understand that, Judge. We've already turned that into you.
All right. So I know your plea bargain agreement stated for ignition interlock half the term, but are you okay or in agreement with there being a monitoring device, a mobile monitoring device?
Yes, Judge, that's just so that we can kind of make sure that we go with the fact or the assumption that they may have a car and then we can go from there.
All right. Going to show you what's entitled waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court.
Yes, ma'am.
Counsel, have there been any such motions? Oh.
None from.
I keep looking this way. Showing you outside the agreement, the state is requesting that your community supervision be for a term of 4 years. There be a TAP evaluation, 120 hours of community service restitution, and 10 days house arrest in lieu of 10 days in the Bear County Jail. Did you understand
Yes,
that
ma'am.
those are recommendations from the state and the court does not have to follow those recommendations?
Yes, I do.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Get two.
State, any evidence?
State offer states exhibits 1 and all attachments.
No objection.
All right. And state, are you going to have any objections to the 10 days house arrest?
No, Your
All right, thank you. You may continue to confer. Mr. Torres, I'm going to show you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that with your attorney?
Yes, ma'am.
Did you understand it and did you sign it in all the appropriate places?
Yes, I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes.
Anything you wish to say on behalf of your client?
No, Your Honor. We're asking to accept the plea agreement. He's done probation before and he's assured me he can follow the rules again.
All right, are you employed?
Oh, no, Social Security.
Okay, and what is the SSI for?
That was for learning disability.
Okay, do you live with anyone?
Well, I have my own place, but I stay with my mom really because I live by myself.
Do you have any children?
Yes.
What are their ages?
16, 14, and 4.
All right, and do you have contact with them?
Yes.
How often?
All the time.
All
All the
right,
time.
all right, and what is up with the tattoo?
Which is, well, it's my daughter. Her feet,
Her what?
her feet, date of birth, her name.
All right, this is what the court is going to do. Court is going to sentence you to 4 years in the prison. The court, of course, is finding you guilty. Suspended and probated for 4 years. There's a $500 fine to be probated. Ignition interlock for half the term. If he provides proof, and I see in the report that he's provide proof of non-driving. Once he provides proof of non-driving to probation and also non-ownership or non-access to a vehicle, then the court will let him remain on the monitoring device that he's currently on. And that will be for half the term. There's to be regular reporting by Zoom or in person. Regular random UAs. $120 of community service restitution. If he would like, he can donate those hours at $7.25 per hour. I always tell people the food bank because there's always a shortage. But if there is some other charity you would like to donate to, you're more than welcome to donate to that, but not the human fund.
No, I done it, I done it to food bank.
You know what that is, right? All right. There is to be, since you don't work, it's going to be full house arrest for 10 days in lieu of 10 days at the Bear County Jail. And that's due to, now there's a lice infestation there. That's due to that and because of the uptick in COVID. So on that full house arrest, you're in your home for the 10 full days. You're not allowed to leave that home for 10 days. You understand?
Yes, ma'am. It can be at my mom.
Hmm?
It can be at my mom's.
I mean, if your mother wants you to live with her, then it's 10 full days at your mom's house. But once you go, you can't leave.
Yes, I'll be there.
All right. There is to be proof of employment or SSI within 30 days. No employment as a home healthcare provider or with minors. There is to be 2 years driver's license suspension, DWI intervention, VIP live, DWI education, a referral to felony drug court, TAP evaluation out of custody, and probation will follow TAP evaluation recommendations. If they request inpatient treatment, we'll start with intensive outpatient treatment. So either way, we'll start with intensive outpatient treatment if he's not accepted into felony drug court. And there's going to be 90 sober meetings in 90 days. Probation, is there anything else he needs? Yes, please. And if he completes parenting classes, he can use those in exchange for the community service hours, or either he can pay off community service hours. So you can either pay it off, but if you complete parenting classes, then the court will consider those hours satisfied. Oh, thank you. Field visit, or more application. All right, is there anything else you need from the court to be successful?
No, ma'am.
All right, I'm showing you what's entitled Trial Court Certification of Dependents. Right to appeal. Did you review it with me? Did you understand it? And did you sign it?
Yes, I did.
Because this is a agreement, because I'm eligible, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. So I'm hoping you're going to be successful at this. If there's an issue, let probation know. If you feel like they're not addressing it, you can always come back to the court. You understand?
Yes, ma'am.
And let me just tell you this, when people drink alcohol, nobody ever expects to get intoxicated and kill somebody.
Yeah.
But sometimes that happens. Don't be that person who goes out, drinks, and you end up killing somebody. No alcohol for you, and you're not allowed to have alcohol, period, while on probation. You're not allowed to smoke marijuana. You can't have alcohol in your home at all. All right, good luck. All right, Mr. Silva, the reason why we're having this compliance hearing is because you have not been taking your urinalysis when you're supposed to take them. And when you have taken them, you have been positive. Do you understand?
Yes, that's what I've been told.
Well, I mean, you know, if you've done cocaine, alcohol, or marijuana.
Nothing. I'm not taking anything.
No, this is what the court has. On June 8th, 2023, you tested positive for alcohol. I'm sorry, you tested positive for alcohol on May 15th, 2023, May 23rd of 2023, May 31st of 2023, June 6th of 2023, and June 22nd, 2023. You are not allowed to drink alcohol while on probation. It does not matter if you're in your home, at the family cookout, at a restaurant, you are not allowed to drink alcohol while on probation. Do you understand?
I do understand.
That is the law. You are on probation. You cannot do the things that you normally would do, whether they're legal or not, while you're on probation. Do you understand?
I do understand what you're saying to me.
Then we have on June 29th, you tested positive for cocaine, alcohol, and marijuana. Then July 6, 2023, you tested positive for opiates, marijuana, and cocaine. You are not allowed to use drugs while on probation in this court. And the drugs that you're testing positive for are illegal. With regards to the marijuana, if you're using marijuana without a medical reason for using it, that has been presented to probation, you're violating your probation. Do you understand?
I do understand.
Now, I understand that you tested negative on April 27, 2023, May 1st, 2023, May 8th, 2023, June 15th, 2023, July 13th, 2023, and July 20th, 2023. Now, I'm reading that you are the provider for your wife and your children. If I have another positive test from you that is not the result of a prescribed medication, what is going to end up happening is a motion to revoke is going to be filed. If the motion to revoke is in proper order, I am going to sign it. And once I sign it, a warrant will be issued for your arrest and you will be picked up wherever you may be. If you're at your employment, they're going to arrest you at your employment. If you're at your home, they're going to arrest you at your home. If you are in pickup line to pick up your children, they will arrest you in the pickup line and they will call someone to come pick up your children, be it your wife or a relative or Child Protective Services. Do you understand?
I do understand.
If a motion to revoke is filed, and if I find it true, you are looking to join up to 10 years in prison. I'm not saying you will be sent to prison for 10 years, but what I am saying is that is in the realm of possibility. Do you understand?
I do understand.
So from here on out, everything you do, there are two questions you need to ask yourself. One, is what I'm doing, could it potentially result in me going to prison for 10 years? If the answer is yes, don't do it. If the answer is maybe, don't do it. Do you understand?
I do understand.
Now, they were recommending that you go to inpatient treatment. He has tested negative today. So I'm not looking at placing him into inpatient treatment today. Probation, what are your thoughts?
Your Honor, I think possibly, he's currently in the intensive outpatient program. I believe he has like 2, maybe 3 weeks left of that. Possibly a drug patch.
Okay. All right. I'm going to alter and amend for a drug patch or the UA hotline. And that will be until further notice.
He is currently, Your Honor, I just want to point out, taking weekly UAs.
Okay. All right, so does probation want both the drug patch and the UAs?
We can stick with the weekly UAs, Your Honor.
All
And
right.
then you've already explained if he tests positive again to file an MTR.
All right, so if you could speak to him and find out which is cost effective for him, the weekly UAs or the drug patch.
Okay.
What type of work do you do?
In construction,
The patch may not be best for him. All right, so the patch may not be best for you because you're working in construction and it's 105 degrees sometime. And there may be some issues with the patch. So we'll continue with the weekly UAs, but I want him on the UA hotline and he's the test weekly. And make sure they're testing for alcohol.
Yes, Your Honor.
Is there anything you need from the court?
Pues me han dicho que probablemente salían positivos porque tenía diabetes, pero no sé, yo nunca me he chequeado.
well, they told me that maybe I was coming out positive because I had diabetes, but I've never checked that.
All right, diabetes, the last time I checked, having diabetes will not give a positive UA for cocaine.
Porque pues ya van varias que me han salido positivos, pero yo no he hecho nada, la verdad.
It's
Yo no
just
sé
that
por qué han salido positivos.
I've had several positive tests and I haven't done anything, so I don't know why they're coming out positive.
All right, here's what I know. And if I'm wrong, I am open to being corrected. If you have diabetes, you will not test positive for cocaine. You will not test positive for marijuana. Now, mind
Okay.
you, that's the last time I checked. If there's somebody who has some study that will show that if you have diabetes, you can test positive for cocaine, you can test positive for opiates, you can test positive for marijuana, show it to me, and I will apologize. But so far, I haven't seen any studies that says that. You understand?
Yes.
All right, so again, is there anything that you have not been given by probation that you feel you need that would help you be successful on this probation?
No,
No, well, that's all.
yo estoy siguiendo las órdenes que me dieron.
I'm following the orders that I was given.
All right, probation, is there anything else?
No, Your Honor.
All right, probation will go over your amended conditions with you. Good luck.
Okay, buena suerte.
Court is calling 2022 CR 7826A, State of Texas versus John Ray Perez. Could I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Michael De Leon for Mr. Pettis.
And are you Mr. Perez? All right, everyone, we're on the record, so I'm going to ask that you please whisper. If you cannot whisper, then do not talk while we're on the record. All right, did you review a document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision? With your attorney, did you understand it? All right, you're going to have to make sure you speak up.
Yes, Your Honor.
All right. Are you the same John Ray Perez who was placed on deferred adjudication in 2022 CR 7826A for the offense of burglary of a building with intent to commit theft on January 10th, 2023 for a term of 2 years? Is that you?
Yes, Your Honor.
State?
Violated condition number 1 on or about the 8th day of November 2023 in Bexar County, Texas. The defendant, John Ray Perez, committed the offense of evade arrest or detention in violation of condition number 1.
How do you plead to that? True or not true?
True. And Your Honor, we waived the other violations alleged in the motion.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, sir.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, Your Honor.
Court will find violation of condition number 1 true. Is there a proposed agreement?
We're asking that you deny the motion, and continue the defendant on, community supervision. We would like to alter and amend the conditions for SATIF. That's gonna run concurrent with the new number 1, concurrent with, County Court 2 case, 72109-7.
All right. And with regards to the county court cause number, is that case still open?
It is, Your Honor, because it's enhanceable, I would like the defendant's gonna go down and plead directly after this sentencing to that, cause. Judge.
All right. And who's the attorney on that case that's in misdemeanor court?
Feel like it's me now. So
You're just coming forward solving problems.
I'll take care of it, Judge.
All right. And Mr. Pettis, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
John Ray Perez,
All right, so what's your drug issue?
marijuana.
All right, we're doing more than SATA for marijuana, are we not?
That's the only drug I just.
I'm sorry, Judge, I didn't hear you.
All right, Mr. Pettis said the only problem he has is marijuana and nothing else.
Your Honor, we don't have any. We don't have any drug tests to confirm that there
Has-
was a violation to his outpatient program.
Have you done anything on probation other than
I went
not
to-
report, pick up a new case and not doing your drug testing?
I went to my classes.
What classes?
The drug classes.
Okay, obviously, they're not working, right?
Right.
So you're just telling me you'd rather go to 2 years to the state jail facility and then come out and use your marijuana?
No, Your Honor.
Then why are you using marijuana? Because I know people think marijuana is not a big deal. But I tell you what, in Texas, it is. And you can't smoke marijuana or use marijuana in brownies or cookies or whatever while you're on probation. You can't even drink alcohol while you're on probation in Texas. So would you like, if you want, I will grant this motion and I will send you to the state jail facility. You will be done. And if you choose to smoke marijuana, that's on you. If you get caught smoking marijuana, you're going to get arrested. That's on you. So if you want treatment, I will give you treatment. But if this is just, I'm doing my best right now to stay out of custody as quickly as possible, but you're still going to use, then now's your time to make the call because you know yourself better than your attorney does. And is there a family member here for you?
No, ma'am.
All right. So you know yourself better than I do and the attorneys do. So if you want, I will deny the motion, alter and amend conditions and send you to SATA. Or I will revoke you and I will revoke you and sentence you to 180 days.
Your Honor, if I may,
Yes.
Mr. Pettis and I had a conversation. I think he wants to avoid having a felony conviction on his record. He doesn't have any other felony convictions before, so that was the reason why when probation recommended SATF, we're like, okay, we'll do it.
Okay.
I had the same reaction when I heard marijuana as well. I'm like, but unless that's different, Mr. Pettis, unless you want to do 180 days and just have a conviction on your record and do 106 months in state jail facility.
180 days.
Yeah,
It's day for day.
day for day, but it's a conviction on your record.
And let me just tell you what's going to end up happening. When I do that, if that's what you want, when you are released, you're going to immediately go back to doing what you previously been doing. And one or two things going to happen. Either you're going to pick up another evading case or something else is going to happen. And you're going to be right back in somebody's felony court or misdemeanor court or whatever. And your problems will still be there because when you stop running, your problem is still there.
No, I'd rather take the help.
Okay. And is there something you wish to say?
Oh, yes, Your Honor. I believe after speaking with probation, his probation will need to be extended 6 months to accommodate the SATF,
Okay.
Judge.
All right, it will be extended. However, if you complete everything, then of course, you can ask for early termination. You understand?
Yes, ma'am.
All right, so this is what I'm gonna do. I'm gonna extend you for 2 years. Alternate main conditions to do a referral to felony drug court. And if felony drug court doesn't accept him, then it will be SATA.
That'd be great.
Felony drug court will be able to probably interview. Next week is a short week, but they may be able to get to you next week. And you need to be honest with them about your issues.
Yes, Your Honor.
All right. Probation, we'll do felony drug court first.
Yes, Judge, and then decided he's not accepted.
Yes, and that's to be while in custody.
Yes.
All right, is there anything else you need from the court to be successful?
There you are.
All right, we can go off the record. How old are you?
I'm 31.
All right, do you want to be the 31-year-old at the prison where somebody asks you why you're here and you say it's for marijuana? All right, do better.
Thank you.
All right, good luck to you.
Thank you, Judge.
Thank you.
Those may be excused.
Yes.
Judge Boyd gave Petties a choice. Take treatment seriously or risk turning a probation problem into a permanent felony conviction. Instead of sending him straight to state jail, she extended his supervision and ordered felony drug court, with SATF as the backup plan if drug court rejects him. Her message was blunt but fair. The marijuana may sound small, but on probation in Texas, it can still cost you your freedom. At 31 years old, the judge made it clear he had one job now: stop running from the problem and start fixing it.